Have you ever really thought about what your rights are when you see those flashing lights in the rearview mirror? I mean, it's a question every single driver has, right? Well, the answer was shaped by this huge Supreme Court of Canada decision that had to weigh public safety against one of our most fundamental rights. So let's get into it and break down the decision that defines exactly where your rights begin and where they can actually be paused right there on the side of the road. Okay, just picture it. It's late, you're driving home, and boom, a police car pulls you over. The officer comes up to your window, asks for your license and registration, and then hits you with that very direct question. How you answer and what that officer is legally allowed to do next was all decided by the landmark case we're going to explore right now. So how did a simple roadside question end up at the highest court in the country? Well, it all started with two separate drivers in Manitoba. They had no idea at the time, but their roadside stops were about to make legal history for all of us. Now, the two cases that kicked all this off were pretty similar, but with a few key differences. On one hand, you have Christopher Orbanski. He got pulled over because he was driving erratically, swerving, ran a stop sign. The police smelled alcohol, had him do those physical sobriety tests, and he failed. Then we have David Elias. He was stopped at just a random roadside checkpoint. Again, the officer smelled alcohol, asked him if he'd been drinking, and had him blow into a screening device, which he failed. So in both cases, the drivers were arrested, but, and this is the important part, it was only after all these initial questions and tests. So after the arrests, things got really interesting. This led to a huge legal challenge. Both drivers argued that their rights were violated. Why? Because they said they should have been told they could talk to a lawyer before any of those questions or tests. And just like that, a fundamental Canadian right was put directly under the microscope. And this is the right we're talking about. It's right there in Section 10B of our Charter of Rights and Freedoms. It's really one of the absolute cornerstones of our entire legal system. It says that the moment you are arrested or detained, you have the right to a lawyer, and the police have to tell you about that right immediately. Now, you might think detention means, being in handcuffs in the back of a police car, but legally, it's way broader than that. In these cases, the government's own lawyers didn't even argue the point. They agreed that from the second the police signaled these guys to pull over, they were officially detained. And if they were detained, well, that means their right to a lawyer was triggered right then and there. So here's the massive contradiction, right? If they were detained, and the charter says you have a right to a lawyer as soon as you're detained, then how could the police ask them questions and make them do sobriety tests before telling them about that right? That is the million-dollar question that the Supreme Court had to figure out. You see, lower courts all across Canada were totally divided on this. The law was, frankly, a mess. Drivers in one province might have had different rights than drivers in another. The Supreme Court of Canada basically had to step in and say, okay, everyone, we need one clear national rule on this. At its very heart, this case was never just about two drivers. It was about this fundamental tension that exists in our society. On one side of the scale, you've got the incredibly important goal of keeping our roads safe from what the court literally called the carnage caused by impaired driving. But on the other side of the scale, you have the fundamental right of every single one of us to know our rights and get a lawyer when we're dealing with the police. And the journey to get a final answer was a long one. First, the trial judges sided with the drivers. They said, yep, your rights were violated, and they threw out the evidence. But then the Court of Appeal looked at it and said, okay, we agree their rights were breached, but the evidence should have been allowed anyway. This kind of legal back and forth created so much uncertainty that only the top court in the land could finally settle it. So, after hearing all the arguments, the majority of the Supreme Court judges made their decision. They found that what the police did was justified. But it's how they got to that conclusion that sets the precedent for every driver in Canada today. The court started with this really key idea. No right in the charter is absolute. There's this other part, Section 1, that basically says all of our rights can have reasonable limits, but only if those limits are set out in law and can be justified in a free and democratic society. It's kind of like the fine print of the charter. So the judges used a two-step test. First, they had to ask, is this limit on the right to a lawyer actually prescribed by law? Now, they found that no law explicitly says police can delay the right to counsel, but they said that power is implied. I mean, think about it. Roadside screening just wouldn't work if every single driver had to stop and call their lawyer. So once they settled that, they moved to step 2. Is this limit justify? And this is how they balanced it out. On the good side of the scale, delaying the right to a lawyer for just a few minutes lets police screen drivers effectively. And the benefit of that is massive. It reduces deaths and injuries from drunk driving. For all the sober drivers out there, it's a tiny inconvenience. On the bad side, well, it's a clear limit on a really important right, and for a moment, it forces drivers to give evidence that could be used against them. In the end, the court decided that the good, public safety, overwhelmingly outweighed the bad.
But it wasn't a unanimous decision. Not all the judges agreed. A minority wrote this really powerful dissent, arguing that the court had gone way too far in limiting such a fundamental right.
And this quote right here, it just perfectly captures their whole argument. The dissenting judges were basically saying that, look, fighting drunk driving is obviously critical, but you can't just invent legal workarounds to get past inconvenient rights just because you're trying to achieve a good outcome. They believed if you're going to limit the right to a lawyer, it has to be done out in the open by Parliament passing a law, not just implied by judges after the fact. So, at the end of the day, the majority decision is now the law of the land. So, let's get down to brass tacks. What does all of this complex legal stuff actually mean for you the next time you get pulled over?
Okay, here is the bottom line. Because of this ruling, police can legally ask you if you've been drinking, and they can ask you to do physical sobriety tests during that initial stop, all before they tell you about your right to a lawyer. The Supreme Court has called this a reasonable and, more importantly, temporary limit on your rights, just for the purpose of roadside screening. But, and this is absolutely critical, the second that investigation goes from just screening to an actual arrest, all your rights kick back in fully. The moment an officer arrests you, they must inform you of your right to counsel immediately and without any delay.
You know, this case is just such a powerful reminder that the line between keeping the public safe and protecting our individual freedoms is almost never a simple, clear-cut thing. It's a constant negotiation. And as this decision shows us, sometimes the answer is a temporary, carefully balanced compromise drawn right there on the side of the road.